I included an hour plus discussion on this YouTube feed from the Hoover Institute from an interview with John Yoo and Richard Epstein. So if anyone wants to consult that, it should be the video just prior to this one in this same playlist. So the principle, so I'm going to discuss Richard Epstein's magisterial settlement on the principle of justice. Principle of justice. So we have a discussion, of course, going back at least to Socrates and Plato on this subject. And by the way, when I say at least to, what comes before that is concrete. And so there is actually a first moment when human beings start in a directive way discussing justice. It's not something that we can say there was 30,000 years of build-up. There may be in some sense, but not in the sense of a conscious discussion about it, as it were, in the I don't want to say in the public square, but in the shadows of the houses at Athens and in other places. So the principle, the old Latin tag, which in English we could translate as "Let justice be done, though the sky fall." Fiat justitia ruat caelum. So this is a crux point. So if we go towards Epstein's side of it, so one can quandary just how serious Epstein was about his statement. There was some jocularity in the end of that video, but of course that always is the case when you're having this kind of discussion, and that was the case with the Socrates as staged by Plato, the Socratic discussions. So 2,400 years ago. The issue was raised in particular was that you have some principles, and the principles are something we'd like to think we could stay with, but the principles are multiple. This is partly my explication of the issue, interpretation of the issue. But justice should be one thing. So then what is justice for? What was raised in the discussion is that there was a case a little after the turn of the century. Going back to 1812 or so. There's a case called something like Hunter's leasee, although they pronounce it in a way that makes it hard to understand what they're talking about. Some guy was leasing some land to somebody else who was, I guess, British or something. But in any case, the content of the case doesn't really matter. What the issue was the supremacy of the Supreme Court over their jurisdiction, whether they could take these cases, what their powers were. And it was the case was decided in favor of giving more power to the Supreme Court rather than more power to the states. So Hamiltonian rather than Jeffersonian decision in some way, but interpret it probably to say that we're giving ultimately, I guess if you're in the Federalist Society or something like that, you'll probably say what this means is that the separation of powers are getting their due and proper say here, because you're giving some power to the Supreme Court, giving some power to the state. You have a federal system at the center and the outside. You separate powers. So Epstein's claim is that if this case wasn't made, it's not just his claim, but he cites several other justices, including Oliver Wendell Holmes and including some other prominent justices, that if this case weren't decided this way, the country would have fallen apart. So then you get the, so you might think that's the Ruach Hayom, that's the sky falling. And we should have stuck, and then the claim is, if we had stuck to our principles, we wouldn't have decided it this way. So apparently there's one argument that says this case really should have been decided on behalf of the state's powers. That's somewhat questionable because the standing practice was already, before it was formalized in this case, to give deference to the Supreme Court, and there's this issue of the supremacy clause. So that was already the standing practice, but they just decided to formalize it somehow. But people are saying on another principle, which appears to be more cogent somehow, it should have been decided on behalf of the states. But if it had been, that would have been the ruin of the country, Epstein is saying. And then he brings in this saying, apparently, that his father said to him when he was a boy, which is, son, sometimes you have to rise above principle, which is then mocked, I suppose, because what does it mean, rise above principle? Shouldn't principle be the highest thing? But again, so this is where, in my explication, what I say is, there's many principles, many arches, many founding points, but justice is one. So what does justice mean then becomes very important. So if we stay with the Socratic version of justice, justice means, is said on analogy with a doctor who has a patient. And so Epstein actually says, if we didn't settle the case this way, the patient would have died, meaning the country would have broken up. It would have been anarchy. Each of the states would have gone their own way with their own courts. There had been, 60 or so big courts beside from the Supreme Court, which would have been tearing the populations of each of the states in different directions, and it would have been, the country would have fallen apart. Which has some cogency because we're talking in 1812 or something, and we know that, of course, the 50 years later or whatever, a little while later, we had the Civil War, right? So, and even today, some people still think maybe Texas will break off. And in fact, there's movements in California to break off, which are not, probably not very serious. But so if you start with the notion that justice means that which improves the patient, rather than this Caddyshack 1980 Judge Smales, I think his name was, as a line saying that he sentences some young man to death, and then he says it's, quote, for his own good, unquote. So can justice be something which is so ideal that it could involve sentencing, it could involve our own death for it? So that's a question about what justice is. And I think if we're in the canon lawyers, and the canon lawyers period after Socrates, after philosophy, after Justinian's seized the property of the school at Athens and shut it down, then we kind of see there's certain places where you think maybe there are things where you're supposed to let the patient die for the sake of letting the sky fall, letting the heavens fall, letting the whole country be destroyed because it's just. That would be, you could kind of see certain cases where that would happen from a Christian perspective, because you say it's absolutely wrong that something be done, and we have to oppose it no matter what, even if it means destruction of the whole country. Whereas if justice means improving the citizens, you can't say we can put this man to death for his own good, because there's no, it's not like the soul is going to matriculate to some finer place. You have to just look at the conditions as they are. So I think in Epstein's version, we get the Socratic version, which is that what he says is, even though we might have a principle, one principle among others that we're breaking, if we look at the whole picture, if we look at justice, sometimes we have to rise above even principles for the sake of improving the patient. So the patient being the country or the body of the citizenry or the people, quote unquote, the people. So I think it's interesting that little bit at the end of that discussion lends itself to some analysis within the whole history of the discussion of law in the West, remembering that for us in the West, philosophy and law move very closely together. But this is a vexed issue because part of the origins of the law, when we talk, I think Ursula von der Leyen, the president of the European Union, just a year ago or so made a statement saying like the Roman law is one of the main pillars of Western civilization. But in saying that, what she leaves out is that the Roman law is really, for the greater part of it, Christian law, canon law. And the canon, the approach of the canon lawyers is not necessarily the balanced, judicious approach, which is supposedly sought amongst the current corruption. So there's a lot of corruption in the law today, especially. And then people say, oh, we must be balanced and judicious. Of course, they point to high principles. But the canon lawyers, what they were doing is more pointing to a mixture of theology and the attempt to balance the inner state of human beings with the law, so that the way what people felt was correct, judging by emotions. It's like people feel angry when they see a murder, for instance. They try to balance people's feelings with the actual law, so that the feelings, and the outer, the sort of look from outside the situation at the whole, like somebody standing outside the country looking in, or standing in a balcony looking at a play going on. They try to balance those two features, but somehow in the light of a theological discussion. So at the same time as we have that theological element in the law, which lasted more than 1,000 years, well, that's an exaggeration, but more than 1,000 years if you include Aristotle as the beginning of theology in a certain sense. But then you also have this Socratic sort of Leo Strauss, prudential sense. So I think Epstein is more on this prudential sense, that you have to exercise a kind of common sense. You can't let you can't let the patient die for an ideal which would just be extinct afterwards. There would be no point, because there would just be nothing left afterwards. You have to consider the generations and generations and what's better for the ultimate health of the patient, which is the country, which is something that's going on for hundreds of years. So, yeah, I think that's something worth considering when we consider the foundations of law in the West.